The officer held the card between his thumb and forefinger at 2:17 p.m. on a Monday in the lobby of the Federal Building on Constitution Avenue in Washington, D.C., and turned it slightly so that the overhead light ran across the surface of it, the way you turn a coin you suspect is counterfeit. "Sir," he said, "this isn't a real ID." The man standing in front of him was 71 years old. He had come in from the cold. The November wind on Constitution Avenue was the kind that found the gap between your collar and your neck regardless of how you had prepared for it. And he had prepared for it. Wool coat, dark gray, purchased at a shop on Connecticut Avenue in 1999, and maintained with the specific care of a man who understood that a well-kept thing could outlast almost anything. But the wind had found the gap anyway. His hands, which held a slim leather portfolio against his side, were still cold from the walk from the taxi stand on 4th Street. He looked at the officer. The officer looked at the card. "I assure you," the man said, "that it is. It looks altered. The hologram's off." "The hologram," the man said quietly, "was designed by the government printing office in 1994. I can tell you what it is supposed to look like." The officer looked up from the card. He looked at the man's coat. He looked at the portfolio. He looked at the cane, a dark wood cane, handle worn smooth from use, that leaned against the man's left leg. And then he looked at the man's face, and whatever he saw there did not change his conclusion. "I'm going to need you to step to the side," he said. "We're going to have to verify this." The man did not move immediately. He held the officer's gaze for 3 full seconds, not with hostility, not with performance, with the particular stillness of a person who has been asked, many times, to make other people comfortable with a situation that was not his fault, and had decided, at some point in the last 7 decades, that he would no longer rush that process. Then he stepped to the side. He set the portfolio on the bench beside him with both hands, carefully, the way you set down something that does not belong to you. He did not know yet that what was about to happen in that lobby would end in a way that no one who witnessed it would forget. Tobena Achebe was 71 years old and weighed 163 pounds, 8 pounds less than he had weighed 4 years ago, before his wife Ngozi had died of a stroke in their apartment in the Columbia Heights neighborhood of Washington, D.C. He was from Onitsha originally, though he had lived in Washington for 41 years. He stood 5 feet 11 inches, which had once been 6 feet exactly. And he carried the slight forward tilt of a man who had spent decades at a desk working on things that required sustained, close attention. He had been born in Onitsha in 1952, the second of 4 children of a schoolteacher and a woman who ran a textile stall at the Onitsha main market. He had come to the United States at 22 on a scholarship to Howard University, where he had studied political science and then law, and where he had met a professor named Dr. Garfield Owusu, who had a habit of assigning his students to draft model legislation as a way of teaching them that law was not philosophy, but plumbing. It had to carry things. It had to hold pressure. It had to work in the dark when nobody was watching. Tobena had been the only student in his cohort who had taken that assignment seriously enough to submit a draft that Dr. Owusu actually sent with a brief cover letter to a contact at the Senate Judiciary Committee. That was in 1976. He had been 24 years old. By 1983, he was a staff attorney in the Office of Legislative Counsel for the United States Senate. By 1991, he was senior counsel. By 1997, he was the person you called when the language of a bill had to be precise enough to survive a constitutional challenge, plain enough for a committee hearing, and durable enough to still mean what it said 20 years after the session that passed it. He retired in 2019, after 36 years, with a letter of commendation from the Senate Majority Leader and a retirement lunch in a conference room on the 4th floor of the Hart Senate Office Building, at which 11 senators came and went over the course of 2 hours, which his colleague Dottie Mwangi later told him was 9 more senators than she had ever seen at any other retirement lunch in her 30 years at the building. He wore his retirement ID from the United States Senate Legislative Counsel's office. It was the card the officer now held between his thumb and forefinger. The card was 2.5 inches by 3.5 inches. In the lower right corner, in text smaller than the rest, were 6 lines of statutory language that specified the legal authority under which the card was issued. Those 6 lines had been drafted, in their current form, by Tobena Achebe himself in the spring of 1994, during a revision to the internal credentialing standards for Senate staff. He had not mentioned this to the officer. He had not yet had the occasion. The bench where he waited was near the north wall of the lobby, beside a water fountain that had an out-of-order sign taped to it with a piece of masking tape that had gone gray at the edges. The fluorescent lights above ran the full length of the ceiling. One of them, 3 panels down from where Tobena sat, had a flicker that pulsed at approximately 8-second intervals, regular enough that after a few minutes you could time it. He timed it. He had been waiting 11 minutes. The lobby of the federal building on Constitution Avenue smelled of waxed marble and the particular dry cold that government heating systems produce, warm air with nothing soft in it, the kind that dried the back of your throat if you sat in it long enough. The floor was pale gray stone, polished to a shine that was already beginning to show the day's foot traffic in long scuff arcs near the turnstiles. The ceiling was 30 feet overhead. The scale of the place was the kind that was designed to remind you how small a single person was relative to the institution above them. Tobena had worked in buildings like this for 36 years and had learned, somewhere around year 8, to stop feeling small in them. You drafted the language, or you didn't. The marble did not change the language. The officer, his name tag read Briggs, R., his belt carrying the full equipment of a Federal Protective Service officer, had taken the card to the security desk at the far end of the lobby. A second officer had joined him. They were examining the card under a different light, one of the flat-up verification lamps used to check government credentials. Tobena could see the blue-white glow from where he sat, a thin rectangle of cold light in the dimmer warmth of the lobby. The 2 men leaned over it the way men lean over a thing they are certain is broken, which is differently from how men lean over a thing they are trying to understand. Behind the desk, through the glass partition, the main lobby of the building continued. People came through the turnstiles with ID cards already in hand, swiped and walked, did not pause. A woman with a rolling cart full of file boxes waited at the elevator with her eyes on her phone. 3 men in suits crossed the marble floor talking without looking at each other, their voices swallowed by the height of the ceiling before they reached the bench where Tobena sat. Not one of them glanced at the bench. Not one of them saw an old man with a portfolio and a cane and a card that 2 officers were examining under a blue light at 2:28 p.m. On a Monday, a young woman in her 20s, seated 2 benches over with a laptop bag and a paper coffee cup going cold, looked over once when she first sat down. She took in the bench, the man, the security desk, the blue lamp. She looked away. She opened her laptop. The cup sat at her elbow untouched for the next 14 minutes. Tobena looked at his hands. The knuckles had thickened over the years the way hands do when they have typed for decades, the joints slightly enlarged, the skin across them thinner than it used to be. He wore his wedding ring still, on the left hand, though Ngozi had been gone for 4 years. He had not thought about removing it. Some decisions once made do not need to be revisited. He had made that one in June of 1981, at a ceremony in a church on Georgia Avenue, and he had not unmade it, and he did not plan to. He had met Ngozi at Howard. She had been studying literature. She had read his model legislation draft, the one Dr. Owusu had sent to the Senate Judiciary Committee, and had said, when she returned it to him, that it was the most methodical love letter she had ever read. He had not known what she meant. She had explained it over dinner at a restaurant on U Street that had since closed, in a booth near the back, with the kind of patience she brought to most explanations. Careful, specific, entirely unhurried. The law, she said, is how a society writes down what it has decided to protect. Draft it well enough, and you are telling the future what mattered to you. That is a love letter. That is exactly what a love letter is. He had thought about that a great deal in the 36 years since. His appointment was at 3 p.m. He had 12 minutes. The appointment was with a policy director at the Government Accountability Office, a woman named Patricia Henley, who had written to him 3 weeks ago asking if he would be willing to consult, on a limited basis, on a language review of a pending accessibility statute. The draft had a section, Section 4, Paragraph 11b, where the definitions clause used an ambiguity that Tobena had spotted in 40 seconds of reading, and that, if not corrected before the bill moved to markup, would create a carve-out that the drafters had not intended and that certain interests would be happy to exploit. He had flagged it in the margin in red ink, in the small, precise handwriting Ngozi had called his surgery handwriting, because it operated as though the margin were a wound it was trying to close cleanly. He had the draft in the portfolio. He stood up. He walked to the security desk. "Excuse me," he said. Officer Briggs looked up. The second officer, younger, no name tag visible from this angle, took a half step back. "My appointment is in 11 minutes, Tobena said. Is there something specific about the card that concerns you? I would like to help you verify it." "Sir, we're working on it." "I understand. The hologram you are looking at is a retro-reflective laminate applied to credentials issued after 1994. The pattern in the upper left quadrant is a Senate seal overlay. If it reads flat under the of lamp, that is actually correct. The design was intentionally non-fluorescent to prevent copying." He paused. "The language authorizing the credentialing standard is in the lower right corner of the card. The specific provision is Section 3, Paragraph 7A of the Senate Administrative Standards Act. If you would like, I can tell you what the original draft said before the committee amendment." Officer Briggs looked at him. "I wrote it," Tobena said, "in 1994. I can recite it from memory if that would help." The lobby was not quiet. The ventilation system hummed. The elevator dinged. The fluorescent panel 3 sections overhead pulsed at its 8-second interval. But in the 12 feet between the bench and the security desk, something had shifted in a way that was hard to name and impossible to miss. Officer Briggs put the card down on the desk in front of him. He did not pick it up again immediately. He looked at the card. He looked at Tobena. He looked at the card again. "I'm going to need to get my supervisor," he said. The supervisor arrived in 4 minutes. His name was Lieutenant Gerald Foss, and he had been with the Federal Protective Service for 19 years, and he arrived in the manner of someone who had been told there was a problem with a credential and had decided, before seeing either the credential or the man holding it, what the resolution was going to be. He was a compact man in his late 40s, with close-cropped gray hair and a deliberate walk, and the particular expression of someone who was accustomed to being the answer rather than the question. He looked at the card. He looked at Tobena. He looked at the card in the way Officer Briggs had looked at it, with a slight tilt that meant he had already decided. "Sir, I'm going to have to ask you to come with me. We'll verify this in the back office, and if everything checks out, we'll get you through." "My appointment is in 7 minutes," Tobena said. "I understand that, sir. This will be quick." Tobena looked at Lieutenant Foss. He had been in rooms, committee rooms, markup sessions, conference calls with general counsels, where the person across the table had already decided before he opened his mouth. He knew the shape of it. He knew the particular way that certainty could fill a room before a single fact had been examined. "Lieutenant," he said, "the card is valid. The language you are looking at was drafted by the Office of Legislative Counsel. I was senior counsel in that office for 22 years. I would encourage you to make a phone call to the office before asking me to go anywhere." Lieutenant Foss said, "Sir, one phone call," Tobena said. "The main line is 202-224-6461. Ask for the duty officer. Give them my name. They will tell you what you need to know. If this story is already moving something in you, stay with me." What happens in the next few minutes is something Lieutenant Foss was not prepared for, and neither was anyone else in that lobby. The woman who made the call was named Dottie Mwangi. She was 64 years old, 5'4", with close-cropped natural hair gone mostly silver and reading glasses on a beaded chain that her granddaughter had made for her the previous Christmas. She had worked in the Office of Legislative Counsel for 32 years and had known Tobena Akebe for 30 of them. She had been at the retirement lunch. She had been the one who told him, quietly, at the end of it, that the 9 senators who had come and gone over 2 hours were not a coincidence and not a courtesy. They had each come because he had done something, specifically, for their work. And they had come to market, and most of them would not have been able to tell you which bill, or which section, or which provision, only that when they needed the language to hold, he was the one who made it hold. She had told him this because she thought he should know it. She was the kind of woman who told people things they should know. Without ceremony, and without delay, because in her experience the world was full of people who had gone to their graves not knowing what their work had meant, and she had made a private decision, sometime in her 50s, not to be the reason that happened to anyone she could reach. She was, at the moment Lieutenant Foss called, eating a sandwich at her desk on the 3rd floor of the Capitol building and reading the draft of a committee report that would not improve regardless of how much attention she gave it. She answered on the second ring the way she always answered, her full name. No greeting, because a greeting wasted time. The lieutenant explained the situation. There was a man in the lobby of the federal building on Constitution Avenue, claiming to be a retired senior counsel of the Senate Legislative Counsel's office. He was presenting a retirement credential. The credential appeared to have an anomalous hologram pattern. Dottie set down her sandwich. "What is the man's name?" she said. The lieutenant told her. There was a pause of approximately 4 seconds. Not a pause of uncertainty. A pause of the particular kind that happens when a person is deciding how to say something in a way that will be understood by someone who does not yet know what they do not know. "Lieutenant," Dottie said, "the section of the Senate Administrative Standards Act that governs the credential you are holding was drafted by the man you are currently detaining. He drafted it in 1994. He drafted the language about the hologram. He drafted the non-fluorescence specification. He drafted the section that describes exactly what an authentic card looks like under a UV lamp. The reason you think the card looks wrong is that he designed it to look that way so that it could not be forged." She paused again. "If you want, I can come down there." "That won't be necessary. I'll come down anyway," she said. "I'd like to." She was there in 19 minutes. She wore a dark coat and a lanyard with a Capitol building ID, and she walked through the lobby at a pace that made Lieutenant Foss stand slightly straighter without quite knowing why. She was not a tall woman. She had the kind of presence that does not come from height, but from 32 years of walking into rooms where the language was wrong and leaving them with the language corrected. She went to Tobena first. She put a hand briefly on his arm, the way you greet someone you have known for 30 years and are glad to see and sorry to be seeing here under these circumstances. Then she turned to Lieutenant Foss. She did not raise her voice. She did not perform outrage or demand an apology or issue a statement. She said, in the same voice she used for committee reports and duty officers and every other thing she had been doing for 32 years, "I'm going to need you to explain to me how this happened, not so that I can punish you. So that the next person who comes through this door with a credential they helped write doesn't spend 40 minutes on a bench waiting to be believed." Lieutenant Foss opened his mouth. "After you let this man through to his appointment," she said. "He's 6 minutes late already." Tobena was 8 minutes late to his 3 p.m. appointment with Patricia Henley at the Government Accountability Office. He apologized when he came through the door. She waved it off. He set his portfolio on the table and opened it to the flag page and pointed to paragraph 11B with his forefinger, and she leaned forward, and they began. He was there for 2 hours and 14 minutes. When he left, the language of the section had been revised in 3 places, all 3 of which would survive the bill's passage intact, and which a senior counsel at the Department of Justice would later describe in a memo to her team as some of the cleaner definitional work she had seen in a federal accessibility statute. She did not know who had done it. The bill did not carry his name. It carried the names of the 2 senators who had sponsored it. That was how it was supposed to work. That was how it had always worked. He walked out of the building at 5:22 p.m. The November wind was still on Constitution Avenue. He turned his collar up. He found a taxi on 4th Street. He sat in the back with the portfolio on his lap and the cane between his knees. And he watched the city move past the window the way it had moved past the window of every taxi and every bus for 41 years. The formal complaint to the Federal Protective Service was filed 11 days later, not by Tobena, but by Dottie Mwangi, who had gone back to her office on the day of the incident and written a 6-page account with timestamps, the badge numbers of the officers present, and 3 specific provisions of federal credentialing law that had been violated during the 44-minute detention. She had written it in the style she used for everything: plain declarative sentences, no adjectives that were not necessary. Every claim supported by a specific reference. She sent it to the FPS Inspector General and to the General Counsel of the Senate and to one other person whose name she placed at the top of the CC line. The review that followed produced a mandatory training update for all Federal Protective Service officers assigned to government buildings in the capital area, covering the authentication standards for credentials issued by the Senate, the House, the Supreme Court, and 14 federal agencies. The training module included, in its second section, a reproduced page from the 1994 drafting history of the Senate Administrative Standards Act, with one passage highlighted. The highlighted passage was the one that described the hologram. In the margin of the reproduced page, in small, precise handwriting, were 3 words in red ink: "See also, context." Nobody at the training had put them there. They had been there in the original document since 1994. Nobody had ever noticed them before. Tobena heard about the training module from Dottie, who called on a Thursday morning while he was at his desk at home in Columbia Heights, reading a draft that a former colleague had sent him for informal review. He listened. He said very little. When she finished, he said, "Did they fix the hologram specification in the training materials, or are they still using the 1998 version?" She checked. They were using the 1998 version. "I'll send them the 1994 original," he said. "It's clearer." He sent it that afternoon, attached to a single-sentence email with no signature block. The email said, "For the training module, the 1994 draft is more precise." The attachment had his name in the document metadata, in the author field, where it had been since the day he created the file. Dexter Foss thought he was detaining a man who did not belong. He thought the card was the problem. He thought the hologram was the evidence. He thought the bench by the broken water fountain was where the story ended. But you cannot forge the thing you created. You cannot call counterfeit the language you wrote in your own hand in 1994, and that has been standing on that card, doing its job, for 30 years. You cannot make a man's work invisible by failing to recognize his face. There are people in this world who have shaped the ground beneath institutions that do not know their names. They drafted the definitions that protect your rights. They closed the loopholes that would have swallowed your protections. They sat in offices without windows and worked on language that had to survive hostile readings and constitutional challenges and the passage of time. And they did it without their names on the cover. Because that was the work, and the work was enough. What Tobena Achebe carried into that lobby was 36 years of work that the lobby itself was built on. What he carried out was the same 36 years, unchanged. The bench did not diminish it. The UV lamp did not disprove it. The 44 minutes did not erase a single word of it. You can make a person wait. You can question the card. You can call for the supervisor and take the thing apart under the light. But you cannot unbuild what someone has already built inside your own walls. The question I want to leave with you is this. If you spent your entire working life building something that protected other people, and those same protections were used against you, not out of cruelty, but out of ignorance, what would you do with what you felt? Would you walk away? Would you send a letter? Or would you sit down at a table in a GAO conference room 8 minutes late and open the portfolio anyway? Because the work in it still needed to be done. Leave your answer in the comments. I want to read what you say. Subscribe for more stories about hidden strength, quiet power, and the people the world overlooks until they change everything. I'll see you in the next one.